Case 23, Morales versus Transworld Airlines. In this case, we are sitting in the Supreme Court of the United States. Facts. In order to ensure that the states would not undo the anticipated benefits of federal deregulation of the airline industry, the preemption provision of the Airline Deregulation Act of 1978, the ADA, prohibits them from enforcing any law relating to air carriers, rates, routes, or services. After the National Association of Attorneys General, NAG, adopted guidelines that contain detailed standards governing the content and format of airline fare advertising, and that purport to be enforceable through the state's general consumer protection statutes, petitioner's predecessor as Attorney General of Texas sent notices of intent to sue to enforce the guidelines against the allegedly deceptive fare advertisements of several of the respondent airlines. Those respondents filed suit in the district court for injunctive and other relief, claiming that state regulation of fare advertisements is preempted by Section 1305. The court ultimately issued an order permanently enjoining any state enforcement action that would regulate or restrict any aspect of respondents' fare advertising or other operations involving rates, routes, or services. The Court of Appeals affirmed. So what's the issue? Whether the Airline Deregulation Act of 1978 preempts states' consumer protection statutes. The court held that the Airline Deregulation Act of 1978 preempts states from prohibiting allegedly deceptive airline fare advertisements through enforcement of their general consumer protection statutes. Let's look into the reasoning. Morales is the first case where the U.S. Supreme Court interprets the ADA. Its holding cuts off a serious effort by attorneys general to improve airline service through general state consumer protection laws. The case turns on the meaning of the phrase related to, as written in the ADA. Morales not only sets out the framework for cases arising under the ADA, but also introduces the idea of principled decision-making, by showing that the legislature makes the law, not courts. That said, notice the upshot of Morales. To obtain the benefits of the NAG guidelines, airline passengers essentially must get Congress to enact a law. Let's talk about NAG. In June 1987, NAG directed the appointment of a task force of states to study the advertising and marketing practices of the airline industry in the U.S. In addition to the study, the task force was directed to determine the nature and extent of existing unfair and deceptive airline advertising practices, and to report a recommended course of action to NAG at its meeting in December 1987. The task force reports and recommendations were adopted by NAG at its winter meeting, with a continuing direction to the task force to receive and examine any comments from industry, consumer groups, federal agencies, and other interested parties, to evaluate these comments, and to report to NAG at its spring 1988 meeting on the advisability of any modifications to the guidelines. The Air Force received written comments from a number of people: the American Association of Advertising Agencies, American Airlines, Air Transportation Association, the Association of National Advertisers, the Council of Better Business Bureaus, Southwest, the Federal Trade Commission, the Department of Transportation, U.S. Air, the National Association of Broadcasters, and United Airlines. Assistant Attorneys General of the task force states evaluated these comments and reported their recommendations to NAG. It is important to note that these guidelines do not create any new laws or regulations regarding the advertising practices or other business practices of the airline industry. They merely explain in detail how existing state laws apply to airfare advertising and frequent flyer programs. Let's review the ADA for a moment. Prior to 1978, the Federal Aviation Act of 1958 gave Civil Aeronautics Board authority to regulate interstate airfares and to take administrative action against certain deceptive trade practices. It did not, however, expressly preempt state regulation and contained a savings clause providing that nothing in this chapter shall in any way abridge or alter the remedies now existing at common law or by statute, but the provisions of this chapter are in addition to such remedies. As a result, the states were able to regulate intrastate airfares, including those offered by interstate air carriers, and to enforce their own laws against deceptive trade practices. In 1978, however, Congress, determining that maximum reliance on competitive market forces would best further efficiency, innovation, and low prices, as well as variety and quality of air transportation services, enacted the ADA. To ensure that the states would not undo federal deregulation with regulation of their own, the ADA included a preemption provision, prohibiting the states from enforcing any law relating to rates, routes, or services of any air carrier. It is important to note that Section 2.5 of the NAG Task Force on Air Travel Industry Revised Guidelines required that the advertised fare include all taxes and surcharges. Round-trip fares under 2.6 must be disclosed at least as prominently as the one-way fare when the fare is only available on round trips, and 2.7 prohibits use of the words sale, discount, or reduced unless the advertised fare is available only for a limited time and is substantially below the usual price for the same fare with the same restrictions. On the other hand, Section 1305 of the ADA expressly preempts the states from enacting or enforcing any law, rule, regulation, standard, or other provision having the force and effect of law relating to rates, routes, or services of any air carrier. Let's understand what Justice Scalia means when stating that state restrictions on fare advertising have the forbidden significant effect upon fares. Beyond the guidelines' express reference to fares, it was clear as an economic matter that state restrictions on fare advertising have the forbidden significant effect upon fares. Advertising serves to inform the public of the prices and products and services, and thus performs an indispensable role in the allocation of resources. Restrictions on advertising serve to increase the difficulty of discovering the lowest cost seller and reduce the incentive to price competitively. Accordingly, where consumers have the benefit of price advertising, retail prices often are dramatically lower than they would be without advertising. As Judge Easterbrook succinctly put it, compelling or restricting price advertising surely relates to price.